moderator for our final panel is Miles Mogilescu, and Miles is an entertainment lawyer, film producer, activist, and writer. His film Union Maids, for which he was both a producer and co-director, was honored with an Academy Award nomination for Best Documentary Feature. He was an early and frequent contributor to the Huffington Post, and to date, over 300 of his articles on a wide range of topics have been posted there. He has addressed the topic of money and politics on The Dylan Ratigan Show and on The Young Turks. Thank you again, Young Turks. And he is also one of the driving forces responsible for bringing this conference into being, and we thank Miles and welcome him.
Thank you. I'd actually written some introductory remarks that I was inspired to by seeing the film Lincoln last weekend, and they were going to be very oratorical and Lincoln-esque, but I've decided to throw them out, most of them, because I want to talk about something that hasn't been talked about today, just for a minute or two, and that's the impact of the 2012 elections on money and politics. And it's because I think there's a media myth that's growing up, which is that because the biggest super PAC supported Mitt Romney and Mitt Romney lost, that money in politics really wasn't such a big deal. And even the liberal media, shows on MSNBC are going, whoopee, Sheldon Adelson wasted his money. See, Mitt Romney lost, Newt Gingrich lost, Sheldon Adelson wasted his money. He can go back to Las Vegas or Macau and count his gold coins coming out of his slot machines because it didn't work. And I say, bullshit. Bullshit. First of all, we were talking last night. Lincoln said that in the film too, I think. We were talking last night, so people came up with some interesting analogies. One is athletes on steroids. And athletes on steroids, pitchers and hitters, don't strike out every batter or hit a home run every time because they're on steroids. But they do it more times because they're on steroids, because they have an advantage that no one else has. Sports teams. The sports teams with the biggest payrolls. The Yankees don't win the World Series every year. The Lakers don't win the NBA championships every year, but they win it more frequently than everybody else. And even in sports, by the way, you have campaign finance regulations. You have salary caps. So in this election, Barack Obama and Mitt Romney raised a little bit more money, but in presidential elections, it doesn't necessarily determine the winner. That's not necessarily the most important place, although it does determine the agenda. And as people have pointed out, how much did you hear about global climate change from either candidate? And now that the elections are over, when the voters said what they cared about is jobs and not the deficit, what do you hear about every day in the news? Deficit, deficit, deficit. And if you read the Wall Street Journal 3 days ago, there was a column by Karl Rove, which he said, the super PACs are coming back bigger, stronger, better. We're going to learn from this time and do it better. And the last thing I want to say on that is perhaps it doesn't matter as much when the two candidates have been chosen for president in the presidential elections, but where the money in politics really matter is where it costs less. It matters in House elections, in legislative elections, in judicial elections. So there's media narrative when people come to you and say, well, money didn't matter, the super PACs didn't dominate. The answer is bullshit. Okay, that's my rant.
As Lincoln said.
So just to go back briefly to introduce this panel, we're here today as part of not one, but two great movements to restore government by and for the people. One has focused on ending the pernicious influence of big money in dominating our democratic system. The other has focused on limiting the power of giant corporations. Both movements have roots going back decades, and one thing I wanted to say is that in Lincoln, you see Lincoln exercising his inner LBJ to twist arms to pass the 13th Amendment, abolishing slavery. But that didn't come about, that was the last stage of a process that came about because of a mass movement, an abolitionist movement that lasted for decades, so that finally slavery was abolished and the rights of African Americans were established. The suffragette movement, the Women's Voting Rights Amendment, didn't pass in a day, in a year. It passed because of decades and decades and decades of a women's suffrage movement fighting for that. So there are two movements here. And both movements go back decades. And both were given tremendous new energy by Citizens United. but they have sometimes been conflated into one movement. There are many people who support both regulating money and politics and ending all corporate constitutional rights, but there are others who support only one or the other of those goals. And on this panel, we'll hear from people who support each of those goals. And then I hope it's going to be a vigorous debate, but I want to kind of borrow from my friend Josh Silver of United Republic to use the analogy of trying to scale Mount Everest, because that's the kind of task we have. And if you want to succeed in scaling Mount Everest, it's better to have various teams coming from various base camps all working to scale the same mountain. And they may not share all the same goals. They may even compete with each other sometime to be first to the top. But when any of them get in trouble, if anyone's in danger, we all have each other's back. So with that, I want to introduce Jeff Clements, I'm not going to give a big bio for the speakers that you have in your program. He's author of the book, Corporations Are Not People. Thank you.
Thank you, Miles. Thanks to everybody. There were two ways to get people to sleep for years. One was to say the words campaign finance reform, and the other was to say corporate law. And the sign that this movement is winning, and we will win, is that we are all here, and people are here across the country to take on those two things and know that they're not boring, that they go right to the heart of whether, since we're talking Lincoln today, government of, for, and by the people will perish from the earth or not. That is the stakes. I think people know it. And what I'd like to do today is talk about something that has not been focused on as much today as we've looked at the impact of money, which is brutal and destructive of democracy. And I agree with so much of the smart thinking and talking that has been done already all day long on that. But also about why I believe, and why Free Speech for People, which I co-founded, believes we also must tackle the corporate power problem, that it's not just money in politics. That is one thing we have to fix, no question. We will not survive as a democracy, as a republic, if we don't fix that. We will not survive as an earth and a democracy and a republic if we don't figure out how to make corporations work for the people and be able to democratically, small d, decide on the powers, rights, duties, privileges that these massive global empires, which is what they are now, have in our democracy. So I'd like, for that reason, Free Speech for People and I both support two amendments that, and you can see it on the webpage for the background as to why in my testimony in the Senate Judiciary Committee that we filed. The one is the People's Rights Amendment, HJ Res 88, introduced by Congressman Jim McGovern from Massachusetts, a Democrat, and a Republican from North Carolina, Walter Jones. It's one of the only bipartisan amendments that are pending, which we like and would not support until it was ready to go in as a bipartisan amendment, because we do need absolutely this American consensus of all parties. And that eliminates corporate, we call it corporate personhood if you want. Personally, I don't think that's always the best term, and I'll talk about why, but it eliminates the fabrication, is how I put it, of corporate rights in our Constitution. They never were there, they're not there now, they don't belong there, and we can affirm that with this amendment. The other one is the Senator Tom Udall's amendment from Senate Res 29, I believe, and was mentioned earlier, and that restores the power to the people in the states and federal government to regulate spending and expenditures and contributions in elections. It makes public finance and citizen funding of elections, all those other great ideas, workable, because you don't get the overwhelming influence of corporate money and individual money. We also support so much of the great work that has been mentioned today, and other amendments, ideas as well, because this is such an important conversation. But I'd like to start, I guess, by going through some foundation stuff about why we think those two amendments are key, or combine them, but those two principles, money in politics and corporate power. we would be able to solve a whole lot of problems if we overturned Buckley and we got the Senator Tom Udall amendment and we got the citizen funding and we got the AA Act. I like that. Professor Lessig's phrase for that, the Anti-Corruption Act. If we put Congress on AA, we'd be making great progress. And so I'm not going to talk more about that. There's been some great ideas, yes, let's do it. Now, what else? I want to talk about why we need an amendment that overturns corporate rights in our Constitution. And as I said, they're not there. So this is really about whether we will allow them to be fabricated and pretend our Constitution means something else than it means. It's not that complicated, in my view. There are a whole lot of complicated cases that will continue to come to the Supreme Court if we no longer allowed corporations to take our rights and turn them against us. There'll still be cases involving newspaper corporations, media corporations, nonprofits. There'll still be cases involving corporate entities, but the court will be required to look for a human being who has a human right claim. And sometimes they'll find it. I mean, there's no reason the New York Times shouldn't have standing to have arguments to make arguments and win about why, as in New York Times versus Sullivan, the Alabama libel law being abused to try to destroy the NAACP and shut down debate about the racism during the civil rights struggle, why the First Amendment protects that. There were two human defendants, many more human defendants in that case, by the way, too. And so that wasn't a corporate rights case, and there'll be lots of cases like that. But we should not, please don't misunderstand, in my view, our Constitution or the jurisprudence to say that somehow we've got to strip corporations of rights. You don't strip a thief of property when you ask for it back, right? So that's what we're dealing with. We're not stripping anyone of anything. And lawyers like to talk about the court decided this, or rights were recognized, and we use these formulations. And in some ways, in the law particularly, that's proper. The Supreme Court, even if it's 5-4 and they're deeply divided, they have decided. That's it. For lawyers who are acting as lawyers. Citizens have a different obligation. And the Supreme Court, when it sort of embarrassingly, frankly, solves a difficulty of corporate law where it intersects with the corporations, they do something like recognize that a corporation has certain rights. These cases, if you go and read them, are an embarrassment to the profession in a lot of ways. Santa Clara never decided corporations don't have any rights. They decided just the opposite. They decided not to decide that. The following cases cited Santa Clara, which had never decided that, and said, we've already decided that corporations have due process rights. You see that over and over again, and it's not 9-0. It's deeply divided. You usually get a dissent, which is embarrassed for the profession as well, and writes out, you hold on here. And that Hale versus Henkel was one of those. So we heard, this Hale versus Henkel is that old case that said the Fourth Amendment in some circumstances applies to corporations. Well, actually, no, it didn't. It did not say that. There was some dicta, as the lawyers say, which is sort of not quite like Santa Clara, but almost, to say, well, in some cases, maybe the Fourth Amendment would apply to corporations, but not here. And Justice Harlan, one of the great judges, is 1906, wrote a dissent saying, hold it, what are you saying there? You don't need to say it, number one, and number two, it's not true. The Fourth Amendment says the rights of the people shall be to be secure in their homes. I mean, the right people, homes, and papers and effects. It would be extremely hard to make a principled, constitutional jurisprudence-based argument that is actually a right of a corporation as a corporation. Now, that's not to say there aren't serious Fourth Amendment implications when corporations are acting. They go the opposite way, though. If we're going to rely on corporations to defend the Bill of Rights and somehow we're supposed to benefit, as General Petraeus found out, we're in trouble because, love letters did not used to be read by the FBI. Talk about personal papers and effects. Google has received 16,000 requests in the last year from government law enforcement officials for people's emails. They've complied and turned them over 90% of the time. So if we've got a Fourth Amendment problem with corporations, we shouldn't be lying awake worrying about, oh my God, corporations might not have Fourth Amendment rights. We should be worrying about our own rights and the values of those amendments. And I could give examples on almost all of the times where the court has supposedly recognized corporate rights. They are awkward attempts to solve a corporate law problem, in my view. And so the reason why we need this amendment is not just so I'll feel better as a lawyer that somehow the Constitution will be more truly interpreted. It's because there are grave implications, as we discovered in Citizens United, as the generation before, at the last Gilded Age, discovered with the line of cases that followed Santa Clara and what was called the Lochner era, where corporate rights, quote unquote, were used to strike down laws over and over and over again, laws like child labor laws, worker safety laws, struck down on this fabricated notion of corporate rights, which don't exist. And I could go all the way back, and I will now, to the beginning of the Republic to show why it is not only correct as a constitutional matter that we not only take on the money and politics problem, which we must, but that we say, no, this is a power struggle right now. The Supreme Court and Citizens United has called a question, essentially. Do people have a right to spend money no matter what and drown out others? The other question is, do corporations have unlimited rights beyond our ability to control them in elections? And I want to frame up why I think that question is the same question Americans have had to wrestle with since the beginning of the Republic, why we will win, why we must win, and why we shouldn't worry about, well, they never actually said corporate personhood in Citizens United, so therefore it's more a campaign finance case. That's only true if we accept that corporations are voices and speakers. So if we just decide, let's all go along with those metaphors, voices, speakers, etc., we don't have to say corporate personhood. But if we go back to the beginning of the Republic, this concern about concentrated power in state-created entities was right there at the founding. There was absolutely no way the founders ever would have gone along with the notion of corporate rights in our Constitution. So don't let anybody tell you somehow we're stripping rights of corporations. I'm sure most of you have heard that quote of Thomas Jefferson, who said he would crush in its birth the moneyed aristocracy of corporations. James Madison, much more moderate, if you will, than Thomas Jefferson of the soak the blood of the tree of liberty. Soak the tree of liberty in blood and so forth. James Madison said corporations may be necessary evils, but only with limitations and guards. And he was talking about outside the constitution, which he's talking about the law of the states and so forth. And so then we get this Dartmouth College case where supposedly corporate rights were recognized. I don't read it that way, and I don't think anyone should. I was at Dartmouth College last week speaking. My father went there, so I grew up hearing that great story of Daniel Webster arguing that case of Dartmouth College in 1819, I believe, and saying, it's a small college, but there are those who love it, and so effective advocacy. But the case is actually, in my view, supports what we're all trying to do. The Dartmouth College case said that the royal charter from the King of England couldn't be, was like a contract, because it said you can take this and go invest and build this college and so forth. And it didn't say this is revocable. So but if you read it, Chief Justice Marshall was saying over and over and over again, he couldn't have been more clear, corporations aren't citizens, they're just creations of the state. They only have whatever rights we, the people, decide to give them under our state laws. But looking at the charter, it looks like the people, in that case the King of England, had not said the charter is revocable. So even then, we could square that decision with everything we're trying to do. Regulate spending in elections, design better corporations, have charters be revocable, There's nothing about that decision that says corporations somehow have rights. If there's a property right implicated in that, it's the right of the people who organize the corporation, put money in, and we're relying on that charter to do that. But the amazing thing at that time was the response of the country. Outrage, even with that. And most of the states passed laws saying, oh yeah, well now charters are revocable. And that's still the case today. Corporate charters are revocable in most states. Free Speech for People has an ongoing petition with the Delaware Attorney General to revoke the corporate charter of the Massey Energy Company, which has destroyed mountains across Appalachia, killed 29 workers, and has 60,000 violations of law. 60,000. So our argument is 60,000 strikes and you're out. But Delaware law today says if a corporation violates the law, violates the privileges that the people have given it, this is Delaware, the most pro-corporate state in the country, then the Attorney General may investigate and bring an action to have the charter revoked. And so we've asked them to implement that law. So that's what Dartmouth College is about, and the reason these states have those laws is because the country recognized, well, hold it, maybe Dartmouth College shouldn't be taken over by the New Hampshire state and turned into state university. But this could be used in other ways too. We have to get control of the corporate charter process, and they did. And so you see this tension throughout our history. The Santa Clara case came in the Gilded Age. We heard a lot of good Adam Winkler's presentation on that, fantastic. But it wasn't like Americans just accepted it. Just the opposite. So there's huge pushback. The Progressive Era, which was, again, Republicans, Democrats coming together, Teddy Roosevelt, Woodrow Wilson, people from both parties, they did 4 amendments in 10 years, 4 constitutional amendments. So we don't have to do just one. And remember, they also did all those other statutory reforms, antitrust laws, the earliest environmental laws, worker safety laws. They knew they were kind of renewing American democracy for a new century to fulfill that vision of government of, for, and by the people. That's where we are. It's another one of those eras, and the court sort of forces a debate that's overdue. That's what Santa Clara and the more significantly what the case known as Lochner, which is out on the, I was glad to see out in the hall. Check out the description of it. Lochner came from the Santa Clara line of cases and was a corporate trump card over democracy. It was overturned. It took till the New Deal, but it was overturned. And that battle, it was about corporate personhood. Read Justice Black's dissent, if you haven't already, in the Connecticut Life case, 1938, where he does a sort of originalist analysis of the 14th Amendment to show why it's absurd to think of corporations having rights in our Constitution. So the question is, are we at one of those periods where it's a struggle for corporate power? Let me just say one thing, though, before I move fast forward to the present. There's this big space, right, between the New Deal and Lewis Powell, the story that Professor Winkler told, and the new, what I call the new sort of Lochner, the new corporate veto that we now have in our country. If corporations had all these rights, supposedly, in the Constitution, imagine a law that said all corporations shall sell any farmland that they have within 10 years. I mean, that sounds pretty radical, right? We don't want corporate farming. A state decided we don't want corporate farming, passed a law saying all corporations shall dispose of their land, farmland, if it's suitable for farming. Doesn't matter if they weren't using it for farming. If it's suitable for farming, they have to sell it. North Dakota passed that law. They went up to the Supreme Court, affirmed unanimously, no problem with that law. Okay, so this is a dynamic process of pushing back at the court. Most of the laws that we pass to address environmental problems, to make the success of the country in the last 50 years would have been struck down if Lochner and the Santa Clara type of cases had continued to hold sway. They weren't overruled specifically by an amendment, but they were overruled by Americans doing what we're trying to do, of try everything. Push amendments, push statutes, push changes in the judiciary, but be defiant about who owns the Constitution and who is entitled to make the rules. It's all of us. And that's what they did. They won. The reaction, as Professor Winkler said, was this corporate speech doctrine. It's just the newest version, and you can call it corporate personhood, call it corporate speech, but here's why it matters. One of the reasons we don't have democracy that works anymore in this country is money, and that is a huge reason. But let me just say a word about GMOs, because we had Proposition 37 here, genetically modified organisms. As you know, most Americans, 90+%, think we have a right to know it. Probably a lot more are very concerned about the use of genetically modified products in our food, and the rest of the world is too. And so I tell the story, well, that lost, as someone mentioned, because of a massive deceptive spending campaign, $50 million to destroy it. But even had it passed, we at Free Speech for People were prepared to intervene in the inevitable litigation that would have been filed by Monsanto and its allies. Now, how do I know that? Because it's already happened. So Monsanto, I tell the story in my book of Dexter Randall. So we do have a democracy crisis, but Dexter Randall shows why part of that crisis is the power that corporations now wield to strike down our laws, this corporate veto. So Dexter Randall's an organic dairy farmer in Vermont, the Northeast Kingdom of Vermont. He's about 65 years old now, but he heard about Monsanto's development in the 90s when it was first coming out of genetically bovine growth hormone, genetically modified bovine growth hormone, sometimes called RBST. It's injected into the blood of cows. It forces the cows to produce far more milk than a cow would naturally because of the genetic modification that they do. It's a drug, so it had to go through the FDA because humans would consume the milk, the cheese, the yogurt, and there were concerns about it. There were concerns about the human health effects. There were concerns about the cattle, the cows, and the animal welfare. There were concerns about the effect on local farms, on the organic farm industry, on the the dairy. It's hard to be a dairy farmer anytime, but competing with genetically modified factory farming is tough. So all these concerns. This led every democracy in the world to ban RBST. It wasn't about disclosure. It was illegal because people don't want it. So Dexter Randall took all these studies and what the other countries were doing to the FDA. He said it was dominated by Monsanto. Nobody would listen. They wouldn't read it. I think Americans are so resilient. I felt that on Election Day. I'm sure you saw that too. This democracy is resilient, and Dexter Randall is one of those resilient heroes. FDA said, no, we're not going to ban it. He didn't give up. He went back to Vermont. He organized rural Vermont. They passed the disclosure law. Governor Dean, I heard a shout out back there for Governor Dean. He signed the law in the mid-1990s. He signed the first disclosure law. It would have required disclosure on any dairy product that had come from cows that had been injected with this GMO. Everybody wanted it. When Monsanto tried to shut it down, their lawyers poured into the state. They said if we had to label, it would cause fear and uncertainty. So Governor Dean, the people of Vermont, Dexter Randall, they stood up and they said, "Well, that's your problem, not ours. We want to know." And the law passed and was signed, and it never took effect. It was struck down as a violation of corporate speech. And so here we are. It was the Second Circuit. It was actually the court in Vermont, the district court in Vermont said, I don't see a problem here. It's not a constitutional issue. People are entitled to require disclosure. Wrong. Overturned in the Second Circuit based on this line of cases that Lewis Powell, 5-4, with great dissents from conservatives like Justice Rehnquist and liberals as well, had created. This notion that corporations essentially have a veto, or at least an argument with a couple of judges who can decide whether the law is reasonable or not. So we are the only country, not only the only country that doesn't make this GMO illegal, we're the only country where its citizens are not allowed to know about it, are not allowed to require labeling. I could go through, as always, Professor Lessig's demonstration was so powerful, so influential, and well done. And ending on climate change, I think, is just right, and I will too, since my time is up. It is one of the problems. We can pretend it's not, but it is one of the tests of whether we've got a shot at all. And that's true for democracy, but it goes beyond that, of course. One of the laws that have been struck down under this new corporate veto that has a relationship to money and politics, but is not relate, won't be fixed by an amendment that only takes money out of politics, is the sort of source case of the corporate speech doctrine, as it's known, the Central Hudson case. And New York had a law in the 80s because of energy problems, and that said, look, the state policy is conservation, energy conservation, yet we've got utility corporations that are trying to drive up demand and are trying to encourage consumption of energy. We don't want that. These monopoly utility corporations regulated by the PUC, they ought to not do that. And they had hearings and they decided on a policy, no promotion of energy consumption. The policy of the state is energy conservation, struck down by the Supreme Court, violation of corporate speech. Joe Camel ads around schoolyards, we tried to do it in Massachusetts when we had the evidence that they were engaged in a fraudulent conspiracy to addict children to a deadly drug. 1,000 feet buffer zones around schools, struck down, violation of corporate speech. I could go on and on. Energy, public health, tobacco warnings, cigarette warnings. Every democracy, and most that I know anyway, now have more graphic warnings on our labels. You wonder why we still have that 1960s one you can barely see on cigarette packages. 2009 Congress, they actually did a bipartisan thing. They said, FDA, come up with new labels. Struck down, violation of corporate speech. So we have a problem getting laws through. We have a problem with the narrow range of debate because of the domination of money. But we have a question of power here, because even when we get a compromised little thing, then it's turned over to the lawyers who take it to court, and we lose. So that's why the two principles to look for in any amendment: does it tackle the piece of Citizens United that overturns the money problem, the Buckley problem, the problem of taking the power away from us to regulate spending. But then the second one is, does it say corporations are, as Chief Justice Marshall said, subject to the people deciding what the rights are in their charters, and we do that through our state laws. Those are the two, and they don't need to be in the same amendment. Maybe they can be, maybe they should be. You don't need to say it's got to be that one. It's got to have both. I would urge just the opposite. Support all of these things. Somebody said, the question was, what should we ask our congressperson? Ask, do you sponsor an amendment? Which one? Well, how about this one too? They can do more than one. There's a long process here. These are going to go out, even if it's not a convention. These go out for ratification by 3/4 of the states. Let's have that national debate. The ask at Congress should be, send amendments out to the states that tackle both these problems. If there's some anxiety about what might happen if corporations aren't allowed to abuse our Bill of Rights anymore, that'll come out in the debate. It won't get into the Constitution but let's have that debate. Don't shut this down before it gets out there, should be the message to Congress. So something like the People's Rights Amendment, something like the Udall Amendment, and all these other great ideas. So, as usual in our country, when the chips are down, it's the bad news is the chips are really down. The good news is so many people are working on so many good things, and as Miles alluded to, we have to work together. Even if you disagree on one thing, help on the thing you agree on. We don't have a magic bullet. We need all of these things to move forward. So let's do it. I was ending on climate change. I saw David Orr, you may know him, the environmental professor at Oberlin, who's just done some tremendous work. I heard him this summer when I was traveling, and he was at the Land Institute in Nebraska, and he said, Kansas, and he said, if you're optimistic, you're not paying attention, and that's disabling, because you think it's going to work out fine, or someone else will do it, or don't worry. So optimism isn't good. But he said if you're pessimistic, that's disabling too, because then you can just tell yourself it can't get done, it's too hard, and that won't. That's disabling. Pessimism is a cop-out. So he said hope. I have hope, and by hope he meant He called it a verb with its sleeves rolled up. So I like that vision of us all rolling up our sleeves and pushing all of these forward, learning from each other along the way, and we'll get this done. I know we will. So thank you very much.
Thank you, Jeff. The next speaker is Garrett Epps, who's a professor of law at the University of Baltimore, and he has a new book out, which he asked me to please hold up. He said his publisher told him that every plug is good for 3 good reviews. Hope it's good for 10 good reviews. I'm going to go to Amazon and buy it because my local independent bookstore closed down. But I intend to buy the book, and all of you, I think you'll find it interesting as well. I hope so. Garrett.
It's called Wrong and Dangerous, 10 Right-Wing Myths About the Constitution. And it's important that you know that it is really, really short. Thanks, Miles, and there's a special heaven for people who hold up your book, so you're in it. I'm very honored to be included with the people who have been in this conference today, the people on this panel, all people whose achievements and commitments humble me. And I spent a good deal of time thinking, what could I possibly bring to this discussion that people who are so involved in this struggle would possibly need to hear. And I realized that I did spend 5 years of my life studying the moment that a lot of our troubles, in essence, began. And that is a history of the framing of the 14th Amendment, which began in December of 1865, when Congress created a joint committee, the Joint Committee of 15, on Reconstruction. And the plan was that this joint committee, which was made up of a really terrific group of progressives in both houses, was going to issue a series of proposed constitutional amendments that would then be passed by Congress and sent to the states, with the aim of changing the political and social system in the country to the extent that there would no longer be a region that we would call the South that could maintain a separate, racially identifiable social and political system. This was going to be a thorough remodeling of the Constitution. And in fact, the Joint Committee did produce 2 proposed amendments, one on representation in the House of Representatives, and one that said Congress shall have the power to require the states to observe the Bill of Rights, which they previously had not had to. And these were very important amendments, but they got lost in a political explosion that occurred because President Andrew Johnson, who is probably the most racist president America has ever had, if you'd like to consider what distinguished company he was in, Andrew Johnson basically declared war on the whole project of changing the South. He said, we are not going to permit any rights to freed slaves. We're not going to permit any change in Southern institutions. And he vetoed the 2 important statutes that Congress had passed at the outset of the session, the Civil Rights Act and the Freedmen's Bureau Bill. And this set off a furious struggle, at the end of which Congress overrode both vetoes. That was the first time in American history that a substantive bill vetoed by a president had been enacted into law, which was a great victory, but it used up all the energy. We can think about things that have happened in President Obama's first term, where suddenly, all of a sudden, crises use up all the energy it hoped to use for global warming and something. And suddenly it was March, it was nearly April, the Joint Committee hadn't produced anything for the Constitution. And they had a meeting and they said, we've got to do something right away. The moment is passing. The election season's going to start. There were some rumors that there was going to be a military coup and Johnson was going to disperse Congress. We have to do something right away. And so they produced what was called the Omnibus Amendment. They said, we'll take all the things we were working on and put them in one amendment. And then we can get that passed. And that became the 14th Amendment. Now, the problem was, when you have 5 parts of an amendment, that's 5 different reasons why some people may vote against it. So they had to put the amendment together at such a level of generality that it wouldn't generate enough opposition that it wouldn't get the 2/3 vote in both houses. And the result is that instead of something clear like the Bingham Amendment that says Bill of Rights applies to the states, we got Section 1 of the 14th Amendment, which in essence is sufficiently oracular that even after it was put in place, the courts were then able for more than a generation to interpret it to mean, something radically different than what it was conceived to mean at the time that it was written. That is, it became, as you can read in Jeff's book, this charter of protection for property and wealth, this restriction on the ability of the people to enact progressive reform. And we had to go through more than a generation of struggle before we began to get the 14th Amendment back to what it was supposed to be. And as a matter of fact, even today, the entire Bill of Rights does not apply to the states. So we're, 120 years later, we're still fighting that battle. Now, what do I conclude from that? Well, I thought there's some lessons that you can draw about constitutional amendments. And one is, I think there are three. And one is be specific. The second is, don't try to fix everything all at once. Don't have an omnibus amendment. And the third is, do make sure, at least, that you fix the problem, that one problem that you set out to fix. And so you think of an amendment like the 13th Amendment, right, which abolishes slavery. It's really hard to misunderstand what that amendment is all about. The 19th Amendment, which says no more discrimination by sex in the franchise. Hard to misunderstand. Those are single-purpose amendments that are very clear. And so I want to suggest that we ought to consider whether it would be a historic mistake to focus our efforts on an amendment that has to do with corporate personhood. I'm very concerned about that. I think that such an amendment might suffer the fate of the 14th. It might be written at such a level of generality that it might end up being interpreted in ways that we can't foresee and would not like. I think the immediate problem we have, and the reason that this hall is full on the day of a very important football game, anybody know the score, by the way? Just put it up there. Is the perversion of free speech doctrine by the United States Supreme Court over a 40-year period that culminated in Citizens United versus Federal Election Commission. That's why we're here, and that's the crisis that we're facing. I do not deny that it's part of a larger crisis, but at this moment, we are attempting to deal with that. And what has happened to free speech began with Buckley versus Vallejo, and those of you who heard Jessica's summary of the history of this, it was a terrific summary, in which the court said, I think out of the blue, that the idea that we the people could set up a system of of election finance that attempted to make sure everyone was heard, the idea that we could set up a system in which one voice or a few voices did not drown out all the others, the court said, out of the blue, that idea is wholly foreign to the First Amendment. I don't know where that came from. I don't think it comes from any sane conception of free speech, and I don't think it comes from the use of free speech in American history. But since then, it has become unquestioned Supreme Court doctrine, unquestioned dogma, that civic equality and self-government are simply irrelevant to issues of free speech. As lawyers, increasingly as scholars, we're really no longer permitted to discuss what I would call the distributional aspects of speech. That is, who gets speech, who has how much, whether we're in a situation where it's equitable and advantageous for everyone, that everyone has access to the ability to speak. You can no longer ask those questions. Instead, the courts ask only one thing, and that is, will a measure in some way reduce the total amount of speech? And if it will, they strike it down. In other words, speech has gone from being a tool of self-government of civic function to being a commodity like any other, to be bought, sold, and used to maximum advantage in the marketplace. The difference with this commodity is, however, that it has a deregulation clause in the Constitution. Speech is a commodity, you can't regulate how it's bought and sold. The point of having wealth is to be able to have more of the world's goods than poor people do. So, what is the good of being rich, the case is almost explicitly asked, if you can't drown out those who disagree with you? I'm not making this up. From the point of view, UCLA 38, USC 28. Okay, where are we at the game? Is it over? It's our final. That's a final, folks. Okay. All right. Yeah. Well, is this a great country or what? Okay. Look at Citizens United from this point of view, right? The electioneering restrictions, this mild restriction that said corporations could not use general treasury funds to engage in electioneering communications within a very narrow window of days before an election, it reduced the total amount of speech. And we know that now to be true, having gone through this cycle, right? If you turn on your TV, there was a lot more speech, right? Barack Obama wants to take your money, right? And you don't ask whether it was good, you don't ask, but it did reduce it, and for that reason, it was struck down. Consider a successor case to Citizens United that I think is equally shocking, and it's just the sort of way in which we've begun to be dulled to outrage that it isn't created as much anger, and that's a case called Arizona Freedom Club's Freedom PAC versus Bennett, which was an attempt to gut the Clean Elections Act that Arizonans passed by popular vote because they put in place a matching public finance. And if you get enough support, enough people give you $5, you get public funds. Now, because of Buckley versus Vallejo, they couldn't forbid other candidates from running either like Bloomberg with their own money or from getting donations from private donors and raising as much as they want. You can't, under Buckley versus Vallejo, you can't outlaw that. But they did say, we're concerned about that happening, and if it does happen, and a privately financed candidate raises much more money than the publicly financed one, that's going to produce not as good a debate, not as good an election. And so we have a provision in which once the private fundraising goes past a certain point, you get some extra funds for your publicly financed campaign. Not a dollar for dollar match, but another allocation of cash, just to keep the dialogue going. Well, at the very beginning of the oral argument in this case, where I was there, the Chief Justice almost comes over the bench, and he says to the lawyer for Arizona, I checked the Citizens Clean Election Commission website this morning. It says that this act was passed to, quote, level the playing field. Isn't that clear evidence that it's unconstitutional? I sat in the courtroom and I thought, we are in the rabbit hole. Alice in Wonderland, right? One touch of equality destroys any campaign finance regulation. And of course, the court eventually decided that this provision was invalid because it discouraged speech. Now, that doesn't make sense either, because in fact, giving more money to the publicly financed candidate encourages speech, since he will take that money and speak, right? But what they said was, yes, but giving more money to the publicly financed candidate may discourage the privately financed candidate, because he might say, I don't want to raise too much money because then my opponent will get more money. So I'll just keep my mouth shut. And therefore, they're restricting speech, and it's unconstitutional. Now, I want to make three quick observations about this. The first is, this decision can only come at a time when free speech has become completely unmoored from the values of the Constitution or American democracy, okay? Second, nothing in either decision concerned personhood. As Adam said, the concept of corporations and persons is not used in Citizens United. In Arizona's Freedom Club PAC, it wasn't a corporation, it was a PAC, perfectly legal under pre-Citizens United pre-Citizens United campaign finance laws. Most corporate personhood amendments I've seen would do nothing to reverse either result. And any new constitutional amendment we pass is going to be interpreted by the same federal courts that we have now. So what I want is an amendment that works, one like the 19th or the 24th, that issues and that deals with one subject and issues instructions to the courts so clear they can't screw them up. And here's a brief outline, and then I'll sit down. And I think Derek is going to talk more about this, and we are, very much of a mind. In fact, I probably just stole from him, but, if you're going to steal from the best is my philosophy. I would like to see an amendment that begins with a preamble that says, free speech is about equality and self-government. That's why we have it. It's not just something that landed from Mars in the Constitution. A free exchange of ideas is essential to these goals, and then says the people have the power to establish mandatory public financing, state and federal, with no opt-outs for Bloomberg, mandatory limits on contributions, as long as they're not too low to allow an effective campaign, mandatory disclosure, because believe it, out there in the system now are the cases by which Jim Bopp and his people want to take down any disclosure. They want to take the First Amendment and make that say you can't require disclosure. That's next on their agenda. And mandatory limits on electioneering expenditures within a certain limited period before an election. And we have to define electioneering expenditures much better than was done in the BCRA so that we don't get into this problem of ordinary news and media commentary becoming a problem. Now, I don't have the language. It's going to take really smart people, but it can be done. If we ask for more, I think we risk failing the whole enterprise, okay? I also feel uncomfortable going to the people with an amendment that uses the language of taking rights away. There is nothing else in the Constitution that uses those words, that uses those concepts. I want to give power to the people, and I believe that if we do, they'll use it, and we will begin to solve our problems. And I think if we succeed with this amendment, there's no reason we can't, as Jeff says, come forward with more amendments. We can have a new progressive era. It took 20 years of work for them to have that 1911, where they brought those amendments into place, the 16th, 17th, and then eventually the 19th. By the way, progressivism also brought us the 18th Amendment, but that probably isn't an example we want to copy. Prohibition didn't work out so well. So I think we should focus on dealing with this problem, the problem that brought us here, money and politics. It is a crisis. We need to focus our efforts. And by what we do in this crisis, and this seems to be the theme of this panel, why what we do in this crisis, to quote Lincoln, we shall nobly save or meanly lose the last best hope of earth. Thank you.
Thank you, Garrett. Our next speaker is Derek Crespin, who's here he is, a vice president of Common Cause. And I'd just like to take a word. This conference was put together by a broad coalition, but the Common Cause staff, particularly Angelique Kronheim in Los Angeles, has done an extraordinary job. Derek has also been extremely involved in passing the instructions in Montana and Colorado that were passed in this past election by overwhelming majorities of voters of both parties. You had a great victory. Congratulations. And this morning's New York Times, lest anyone think anyone hasn't noticed, there was a lead editorial on the importance of those 2 votes in Montana and Colorado, and go out and read a copy of it. So with no further ado, Derek.
Thanks, Miles. Is somebody working on getting the PowerPoint working? We got a screen coming down. Adam's on this. I don't know where the computer is. I got a little gizmo, but there we are. Okay, but this is Trent's PowerPoint, and it'd be more helpful if I had mine. Picky. Talk mostly or entirely really about the problem of how to deal with Buckley versus Vallejo and reversing that through a constitutional amendment. That's it. And this is based mostly on my experience when I was living in Washington, D.C. for about 5 years and was the sole advocate for a constitutional amendment in the 1990s that was proposed by Senator Hollings and Specter. And I watched the Senate debates unfold around that. And if you think watching Roberts is into the rabbit hole, you should listen to Mitch McConnell.
That's the rat hole.
So I have spent a lot of time thinking about how do we draft an amendment to deal with the counter-arguments that were raised during those Senate floor debates. And I'm going to pick up where Garrett left off and suggest that it would behoove us to be as specific as we can, not only to ensure that future courts interpret the 28th Amendment in the correct way instead of as they have with the 14th Amendment and granting them a lot of leeway, but also to deal with these counterattacks from a strategic point of view. So I want to start with a question that came up during the last panel on do we actually want the amendment to say money is not speech, or that there should be 0 protections for spending money in politics? And I think the answer is no, and I think we need to be very clear on that, even though there are folks in this movement who have been calling for that. I think the person who said it best is Justice Stevens, and it's quoted up there, who says, money is property, it is not speech. That's a no-brainer, right? But the right to use one's money to hire gladiators or fund speech by proxy certainly merits significant constitutional protections. These property rights, however, are not entitled to the same protection as the right to say what one pleases. But imagine, if you will, a world where we have full public financing for 2 candidates, and they haven't received a private dime, but neither of them wants to talk about an issue that you think is important. Maybe it's gay marriage. Maybe it's a war that's going on. Maybe it's corruption. Number 2 issue, which neither presidential candidate wanted to talk about. Are we actually saying that you as a private citizen cannot spend $25 on a bumper sticker or a lawn sign or a blog or something like that to raise that issue that the candidates don't want to spend? I think the answer is no. We want people to be able to make independent expenditures, just within some limits. So, in my view, it's not that we want to get all money out of politics, it's we want to get big money out of politics. We want to set limits. So, then we get to the version of many of the amendments that have been introduced that say something to the effect of Congress shall have the power to regulate spending of money in respect to federal elections. Okay, but then the question is, do they have complete power? Like, could they set any limits that they wanted whatsoever? I think some amendment proponents and organizers actually think yes, and they would answer that question yes, and the courts would have no power to do anything about it. But we're not talking about eliminating judicial review. We're not talking about trumping the Equal Protection Clause or the fact that courts are going to balance the 28th Amendment against other parts of the amendment. You can imagine a law that limited campaign spending or campaigning to 4 weeks, like they do in other countries. They have some time limits. Limit candidate spending to $100. Banned independent expenditures. This would be a wildly popular proposal, right? And gave incumbents $5 million in franking privileges. I think we want the courts to step in a situation like that. But there are then two problems that come about by inviting judicial review. One of them is a legal concern. Do we just give the Supreme Court free rein to decide however they want what limits are okay and which ones aren't? I mean, the Buckley Court already actually ruled, okay, sure, Congress does have the power to set limits on contributions and money in politics, but they have to meet a compelling state interest, and we're going to decide what is a compelling state interest and what isn't. And you guys don't get to decide. And leveling the playing field is not a compelling state interest. We'll be getting there. My worry is that just having language authorizing them gives the court too much leeway to decide for themselves which limits are okay and which limits are not. We could wind up with a situation where a court said, sure, you can have a speed limit, right, but it's got to be 500 miles an hour. We're looking at this in Montana right now, where they're saying the contribution limits there are just too low. We don't like them. You can have limits, sure, but not limits that would actually limit anything. That's the policy concern. Perhaps the bigger one is the strategic concern and what Senator Hollings called the straw man arguments. There's a paper I circulated electronically. You can read more of this, quoting from the congressional record from when this was on the floor. But Senator McConnell was very fond of posing these parade of horribles on the Senate floor. And the most important part is saying, you know, look, do you really think, my fellow Democratic colleagues, that at some point in the future, when Republicans own everything, because we will someday, would you trust a Republican Congress with a 60-plus majority and a Republican in the White House that they won't seize the occasion to limit political activities by leaning liberal groups such as labor unions, the media, and others? Would you not like the court to be able to stop such an effort on the grounds that it violated a First Amendment? And I would. Now, Senator Hollings had an answer for this. He said, oh, that's not going to happen, because my amendment says they can only set reasonable limits. This was actually in the text of the Hollings-Specter amendment. And, of course, we're going to have judicial review, and the courts wouldn't let Congress pass any of these parades of horribles that you're raising, Senator McConnell, so don't be so silly. Well, the question then becomes, who decides what's reasonable? Don't really even have to say anything, do you? So one piece of progress we have made since the 90s is all current versions of constitutional amendment resolutions don't have the word reasonable. The congressional staff that drafted these things have figured out that that wasn't going to work. But they haven't replaced that word with anything. And so the court could still write in that word themselves. They could interpret that amendment however they wanted in the future. I believe what we need to do is picking up where Garrett left off and say we need to take on the core problem in Buckley v. Vallejo and set that straight so that that will guide future court interpretation. And that is to establish an equality rationale in this amendment. This is how we get out of the rabbit hole. So there's the same quote that Garrett read about it's wholly foreign to the First Amendment to restrict the speech of some elements of our society in order to enhance the relative voice of others. That's just wrong. Tell that to the woman arrested for speaking 3 minutes and 1 second at the city council meeting, where they limited her speech to 3 minutes. Tell that to the Commission of Presidential Debates, whose moderators try very hard to limit the speech of each candidate so the other one can speak. Tell that to Miles when he tries to shut me up, saying, your time is up, we're limiting your speech so that other panelists can talk. Tell that to the Occupy folks who were said, well, you can speak in this square, but only for so long. So, how do we do this? There are a couple of ways, and I am not wed to any particular ways. One would be to actually put language in the preamble of a resolution saying, be it resolved by both chambers of Congress that in order to enhance the purpose of political equality, boom, 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 then you would actually get into the body of the amendment itself, in the text of the amendment itself. I think that that could work, but I think 100 years from now, we need the 28th Amendment to speak for itself in its own terms, and the people 100 years from now may not be looking at that be it resolved portion of the resolution that moved through Congress. You know, you've probably all met members of Congress who walk around with their Constitution high and mighty and they whip it out and they like to read on the floor. I think we need them reading these words, and it can't be only in a preamble or only in the legislative intent. I think we need every school kid reading these words 100 years from now so it is beyond dispute about what we meant right now when we're doing this. So another way to do it would be to put it in the actual text of the amendment. There's a suggestion there that's similar to what we used in a resolution called Prop G in San Francisco that passed by something like 81% of the voters this past November. And it talks about the goal of all citizens, regardless of wealth, shall have an equal opportunity to have their vote counted and to express their political views to their political citizens. Notice that one actually sneaks in something about Bush v. Gore. You don't really have a right to have your vote counted in presidential elections right now. So a side benefit of that text. Or another idea that's been suggested to me recently is we could follow the amendment of the Second Amendment, and Adam's an expert on this, which actually kind of has a preamble in its own text, right, which says, a well-regarded militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Okay, so that tells us why that amendment was put there. It wasn't about hunting. We can all agree on that. There's some disagreement about what they meant by militia, and there are a lot of court cases about that. But it's an example of a preamble in the body of an amendment to the United States Constitution explaining to the future courts, here's why we're doing this. You should interpret any future laws in this light. So, one idea for that would be a well-regulated discourse. It's kind of like different than a militia, but it's being well-regulated. Yeah. Being necessary to maintain the equal creation of all citizens before the government and the ability of the electorate to inform themselves of diverse inputs, then there shall be limits. Now, another thing to think about, most of all of these amendments say Congress shall have the power to regulate spending of money with respect to federal elections. Well, Larry said Congress had 9% approval rating. Well, by August this year, it was up to 10. I don't think people really want to be giving Congress more power to do anything right now. Incumbents actually do have a tendency to be somewhat self-serving. Look at gerrymandering. Look at voter suppression laws, poll taxes, abuse of Franklin privileges. In my Common Cause work, I have run across enough problematic situations with incumbents trying to entrench themselves. I'm not really keen on just giving Congress unlimited power. An alternative way of phrasing the same thing would be to put restrictions on the courts rather than additional powers to Congress and say the courts shall strike no law. The other interesting thing about that is it would leave open a totally different policy idea of not having Congress set their own limits. Perhaps state legislatures could set limits for Congress, or they could be set by voter initiative. That's preempted by the 1974 FECA law, which is by statute. We could change that now. But if we put Congress shall have the power into the US Constitution, we can't change that. Now, it may be unlikely that Congress would propose giving up their power to set their own limits, but if Larry and Jenks succeed and we get a constitutional convention to do that, you could envision all sorts of things. I think it's worth thinking about. Another word to focus on is regulate. And this has been a change by the congressional staff that come up with these things from where Hollings' inspector was, which was much more on limits. I think what they're getting at when they say regulate is they really mean both limit individual contributions and ban corporate treasury contributions. This was in reaction to Citizens United. But the trouble with that is it suggests that Congress could ban independent expenditures, which gets back to that hypothetical situation I posed before, but it's not really that hypothetical. Members of Congress would love to ban independent expenditures and have them be the only people that speak about their own political futures. Look no further than Elizabeth Warren and Scott Brown, right? Their whole big thing was, okay, we're going to create a deal so that none of these outside groups speak. So I'm not sure regulate's the right word. An alternative to that would be And then this, again, combining some of the previous slides and ideas, but courts shall strike no law through setting limits on the use of wealth to influence candidate and ballot measures, nor any laws separating funds intended and privileged for commerce from those intended for political discourse, as a way of dealing with the idea of banning corporate treasury funds, for-profit treasury funds, from politics. There's some more details I could say about that, but I'll skip them. Another thought would be the term expenditures. And I think this can also get us into a set of weeds that we don't need to go into. Many of the aversion amendments say you can regulate the raising and spending of money. But that immediately leads Mr. McConnell to go, really? Well, what about New York Times editorials? They cost money. It's an expenditure of money to print the New York Times. What about even things that aren't news, but are clearly opinion? Fox News commentary, when Karl Rove gets on Carl's News, on Fox News and expresses an opinion, is that an expenditure? What about a Michael Moore book? The Solicitor General kind of screwed up in front of the Supreme Court by suggesting Congress could ban books. Remember that? What about a movie? A pay-per-view movie. What's interesting is the Supreme Court really could have drawn a line in Citizens United between the pay-per-view movie that is pretty much like free press, right? People are buying a newspaper, they're turning on Fox News, they were paying money to watch this movie, and advertisements aimed at promoting the movie or promoting, attacking, supporting, or opposing a candidate. So one way to deal that would be to carve out in the text of the 28th Amendment a media exemption, right? And there's some versions that do this. I think that gets a little bit tricky. Is a blogger a media source? A tweeter? What's a bona fide news outlet? Are we going to let the Federal Elections Commission decide, especially after what Trevor just told us about the Federal Elections Commission? I think, here's a great example. In Montana, this year, the most widely distributed newspaper, by which I mean a piece of newsprint that did contain news, was distributed to 120 households by the organization American Traditions Partnership, which is the group that takes mostly money from extraction corporations and uses it to promote, support, attack, and oppose candidates, and that sued to overturn Montana's 100-year-old law banning the use of corporate funds for those purposes. They put out a newspaper. That's a picture of it. And they distributed that to more households in Montana than any other newspaper right now. Does that count as a media source? I think the answer is no. And I think the way we draw the line is between what I'll call push content and pull content. And I'm still looking for the right words to accomplish this in amendment. Maybe people have some ideas. I think it might be advertisements instead of expenditures. We all know in the New York Times, there's the New York Times editorials, there's the column pages, but then there are advertisements that are only there because somebody paid to put them there, to push their speech on somebody who otherwise wouldn't have read that. Would allow us to draw a distinction between free ads that the Seattle Times recently offered to candidates, valued I think at $30,000, and their own editorials. If we just exempted media corporations from all of these things, does that mean that a media corporation like News Corp could just send out unlimited direct mail pieces using that media exemption, attacking or promoting candidates? I think no. But on the programs that people are opting into, yes, they can say whatever they want. Karl Rove can say whatever he wants. That's not an advertisement. Where it really gets interesting is like literally the same words, but one of them's a Google AdWords link versus another link. I think we can draw a line between the two of those. One is advertising, one is user-driven content. So these are some ideas of how we might be more specific in drafting an amendment to deal with Buckley than the previous amendments have been. This would be how it could be put together. saying a well-regulated discourse being necessary to maintain the equal creation of all citizens before the government and the ability of the electorate to inform themselves of diverse viewpoints. The court shall strike no law establishing a level playing field through limits on the use of wealth to purchase advertisements or otherwise unduly influence candidate or ballot measure elections by overwhelming the speech of others, nor any law separating funds intended or privileged for commerce from those intended for political discourse. Now, I'm sure that's not perfect, but I offer it as an improvement to the current drafts that I think we need to look seriously at. So final thought, as my time is about to be limited, I want to just say, this has been my passion for some 15 years now, overturning Buckley. I feel very strongly about it. I think it's very important for the future of our country. I don't think it will solve all of our problems. And in the course of this work, I've run across many wonderful people who think we need disclosure and public financing, and to deal with the revolving door in ethics, and to deal with this bogus idea that corporations are people with constitutional rights. And I get frustrated when I hear people who agree with me say those things are distractions. They are not. They're really important. I have never won over a supporter to my cause by telling people that they were barking up the wrong tree and caring about theirs. And I think we do a disservice to our own causes and our broader movement when we suggest that. I think we need to not say that any reform is too small bore or any reform is too hard, including a constitutional amendment. We can do this. We will do this. Nothing is too hard for Americans. We fought a civil war. We beat Hitler. We gave women the right to vote. We've done some hard things. Okay, this is hard. We can do this too. Don't use that as an excuse to say you're not going to help. Thanks.
Okay, let's have
We can't, we can't do like 5 minutes of questions, or?
Let's get some questions. Don't you think?
Yeah, let's get a few questions from the floor if we,
Let the people speak.
let the people speak.
Limit
Yes,
the
over
speech
here on
so
the
that
right.
others may be heard.
Yes?
Hi. I wanted to ask, Bill Gates, he has $66 billion, right? That's an economic inequality problem. I mean, you count that money at $100,000 per second, and it takes you 7.5 days to finish counting it. Okay, we have other problems like business monopoly, right? We have also a government, right? The government is the biggest thing we have for solving our problems. It can regulate everything. Ask BP. They just got fined $4.5 billion. Who else can fine BP like that? Or throw their CEOs in jail? My question is this. Isn't it true that more than half of what's wrong with this country is that so many of its right-wing and right-wing leaning political candidates get backed by political campaigns and other campaigning operations that get so much bigger than it's fair for them to get? What I mean is, backed by political campaigns, super PACs, etc., that spend so much more than it's fair for them to spend. And isn't the only way to solve that problem a constitutional amendment? Thanks.
So, yes, a constitutional amendment. But I want to address the right-wing phrasing because, I think we need to take seriously the idea that we wish to talk so that others will hear, and we need to get to 80%. And so...
I agree, but it is a fact.
I know,
It is a fact. It's not
okay.
left-wingers.
All right, let me try to answer the question. I distinguish between what I would call corporatists and conservatives. And I take that distinction from people like Justice Rehnquist, very conservative justice. He opposed and dissented in elegant and powerful language, all of those corporate speech cases, one after another. Bellotti, he said that the people owe their existence to something higher than the Commonwealth of Massachusetts, and if they decide to regulate corporate spending and referendum, they have a right to do that. He dissented in the utility cases over and over again. He was conservative. There is a due process case from the mid-1980s where Lewis Powell did an extraordinary thing. He used the equal, and 5 other justices. I don't want to keep picking on Lewis Powell, but there's a narrative about Powell in my book, Corporations Are Not People. And he sort of led this corporatist movement, and he did use the Equal Protection Clause to strike down an Alabama law that allowed that Alabama had a slightly higher tax on out-of-state insurance corporations than for in-state. And there was a lot of reasons for that. He said it violates the Equal Protection Clause. These corporations have equal protection rights under our Due Process Clause. And another conservative, Sandra Day O'Connor, was just agog. She was new to the court, and she used words like astonished at that in her dissent. She said that it was a pretext to give corporations more power. And then she went on to compare it to the Lochner era and the Santa Clara cases. She was very conservative, no doubt about it. Now, the final thing, I could give lots of different examples. The final one, though, I would look to support this is Montana, where Derek Cressman and Common Cause did such a great job at leading it. We Have Free Speech for People were there. Many others were there, of course. And in Montana, which voted for Mitt Romney, 75% of the voters said that they want a constitutional amendment. They want the amendment to say corporations do not have constitutional rights. They also want the amendment to say that we can get money out of politics, and they instructed their elected leaders to get to work on it. If you go to the Secretary of State's office of Montana to look for the results, it says I-166, corporations do not have constitutional rights. 75% to 25%. There are a lot of Republicans, a lot of conservatives who voted for that. So I think we would actually, now, to your point, sir, 75% of the super PAC money went to the Republican candidates. But so I get where you're coming from, but I think we have an opportunity after 40 years to split this corporatist conservative alliance. And I would say sometimes there's a Wall Street Democrat alliance. There's different alliances, and we can realign all these politics if we come together and distinguish between conservatives who we don't agree with on things, and then corporatists who are quite different in some circumstances.
Can I say something about that? Have you got time for me to say something briefly about that same question?
How much time? I want to read at least one question from the other room.
Another question over here. I asked.
I'm sorry. I wanted to read one question from the overflow.
Oh,
Garrett, why don't
yeah, I just want to say in terms of the left-right thing, if we go into this saying we've got an amendment, we're going to crush these right-wing super PACs, see yourself, let's see ourselves as others see us. I think there are people on the right of this country, people of goodwill, who think Barack Obama is the biggest hypocrite who ever lived to talk about money and politics. When he personally gutted the matching fund system for presidential, he was the first presidential candidate to step out. And I think we need to say this is not about the left and the right. It's about, do you think our candidates ought to be spending all of this time raising money from rich people, or should they be spending time governing us? And I think if we do that, we can be heard.
Actually, I'd like to give people in the overflow room a chance to ask questions. I have one written question that I'm going to read. We've referenced abolitionists, suffragettes, civil rights movements, et cetera, succeeding in passing amendments. All use mass nonviolent civil disobedience. What are your thoughts on using mass nonviolent action to get big money out?
The Civil War did involve some violence, but I'm not thinking that's a useful tactic now. And yes, of course, I think we should be using mass nonviolent. I mean, the single best thing that happened to the constitutional amendment movement was Occupy, right? I mean, after that, U.S. senators were falling all over themselves to co-sponsor an amendment. I don't think it was a coincidence that the Los Angeles City Council resolution, which then sparked 300 other city council resolutions, came right after they kicked Occupy out. Man, those feel like, oh, we really got people mad by doing that. We better demonstrate something good. I know, but they passed it after they kicked him out, right? I think Occupy helped. I'll just put it at that. And I think we need more of that type of protest.
So I asked a similar question this morning, and I was mentioning an international comparativist approach regarding Norway's policy of gender quotas in political parties, which was just a pro tem measure to see how equality worked. And it turned out to work great. They didn't need to renew measures, and all parties roughly nominate 50-50. And it's worked enormous benefit towards gender equity. What I was wondering for an American application is something tied to a basic finance with a moderate finance measure to imply that equality should be a necessary mandatory prerequisite for any moving future of any political party. And another thing to think about too is what Norway just did in 2009 with corporate boards of directors, requiring that any company that receives federal benefit to have some measure of gender equality, even 40-60, like there's some leeway. But that if you're going to be federally subsidized, much as federal subsidy of racism is forbidden by the Civil Rights Act.
Question so they can answer it.
Yeah. So what do you think?
Anyone want to take it?
I think it's a very interesting idea. I've not spent enough time thinking about it to offer anything intelligent to say. Other than, as a movement, I think we need more people like you raising good ideas.
I see Mary Beth getting very restless here, and we have to wrap up this panel. Thank you very much. It's been a terrific panel. I'm going to go to the breakout session.